My name is Reuben Tyler. I'm a New Zealand barrister and a shareholder and director of Trustees and Fiduciaries. I'm going to talk to you today about how an asset protection trust actually works. We need to have a look at the steps that are taken by a creditor. The creditor commences the action against the client and gets the first judgment against the client for a sum of money. The creditor then examines the client to identify what assets he might have and asks for a warrant to seize those assets. At that point, the creditor finds the assets are actually held by a domestic trust and that the client has very few assets. The creditor then applies to set aside the transfer of assets to the trust on the grounds of fraudulent transfer. A second judgment is then issued, setting aside the transfers to the trust. The trust assets are seized and you have a personal judgment against the client being satisfied by trust assets. If the trust is settled in the Cook Islands as an asset protection trust, then the first judgment for the sum of money is recognised in the Cook Islands. So it is recognised that the client owes a sum of money to the creditor, but the second judgment setting aside the transfer of assets to the trust is not recognised. And that's because Cook Islands law protects trust assets against foreign fraudulent transfer judgments. The creditor's options then are limited to commencing de novo proceedings in the Cook Islands. The creditor will need to argue fraudulent transfer of those assets to the trust under Cook Islands fraudulent transfer law, and that law is very different to US fraudulent transfer law. If you refer to the slide, probably the starting point is contingency fees and costs. Contingency fees are not permitted in the Cook Islands, which means that you'll need to pay your legal fees in advance. Also, costs are important because if you allege fraud and fail, then you will be exposed to full party costs. You may also be asked for security for costs to be paid at the commencement of the case. The second most important feature of Cook Islands law is the limitation statute. The statute provides that an action alleging fraudulent transfer must be filed in a Cook Islands court within 2 years of the date of transfer of those assets. If the action is not filed within that time limit, then it will be time barred. Another important feature of Cook Islands law is that we do not have any law of bankruptcy. Bankruptcy law has not yet reached the Cook Islands, so that there is no recognition given to a trustee in bankruptcy, and because of that, there is no recognition given to bankruptcy clawback provisions. Our fraudulent transfer laws are also quite different. It's old law, which has two important tests that the creditor must satisfy. The first test is the creditor must establish that there was an intent to defraud, and the second test is the creditor must establish that the transfer of property rendered the client insolvent. Both those tests are personal to the creditor and they do not relate to other creditors. In addition to that, the burden of proof that the creditor must meet is the criminal burden beyond reasonable doubt. When we look at intent to defraud, we also have to look at a number of irrebuttable presumptions against intent, including where a trust is settled in advance of an event. It's what we call future fraud, where the trust has ongoing participation by the settlor, and there are also a number of time limits that prevent an intent to defraud. The consequences of fraud are also important under Cook Islands law. The transfer of the asset is not avoided. The trust itself remains intact, but the trustee is obliged to settle the specific creditor in relation to that transfer of property. There is also important procedural law, which means that fishing expeditions cannot be conducted unless the various tests are met. The same law applies to the issue of injunctions or freezing orders, so the tests must be met before those orders will be issued. So in summary, Cook Islands asset protection trusts are not about hiding assets. Instead, they're based on proper application of Cook Islands law, and that law is favourable to trust settlers, giving a high degree of certainty to trust settlers. Cook Islands asset protection trusts have a track record of achieving early settlement of litigation.